Good afternoon, folks, and welcome to this week's episode of the Legal Beagle podcast. You might ask yourself why I'm wearing this big Patagonia jacket and why I have these big mittens on. And that's because this week we're going to talk about slip and fall cases, specifically ones that occur on ice and snow, which are more found in areas like Denver, Colorado than Phoenix, Arizona. However, they happen in northern Arizona in places like Flagstaff. They can happen in California and places like Big Bear. So you need to be aware of what the law says and what the law allows. For this week's episode, I'm going to focus in more specifically on Denver, Colorado, or I guess Colorado in general, because they just had an epic amount of snow drop in Denver over this past weekend. In fact, it was a historic blizzard that dropped over 27 inches of snow in Denver. So to say they got hit with snow is a little bit of an understatement. What's important to understand is if you are involved in a slip and fall on ice or snow, how does the law work and how does Colorado law work in your favor or maybe work against you if you find yourself in that situation? So let's start with the California Revised Statutes. These are CRS for short. CRS 13-80-102 talks about a tort claim, which is what a personal injury claim would fall under, more specifically a slip and fall claim. And you have 2 years from the date of the slip and fall to bring your claim to resolve your claim or bring your claim in court in order to preserve the right to continue the claim. If you don't do that, then you're going to be barred by what's called the statute of limitations. We've talked in the past about deadlines. That's the deadline to bring your claim. And if you don't do that, then you're not going to have the opportunity to pursue your claim anymore. It's also important to know that under CRS 13-80-102, the same thing applies to your personal property. So say you slipped on a patch of ice outside of a business and you break your really expensive watch. You have 2 years from the date of that fall and the date that the watch was damaged to resolve that or file a lawsuit to preserve your right to bring the claim. Otherwise, you lose the right to have your claim made. Colorado is a little bit different than some of the other jurisdictions where we practice. We have offices in Denver, Colorado, in Phoenix, Arizona, and in San Diego, California. In Denver, Colorado, where Colorado is a state, they have the premise of contributory negligence, which is the same as you would find in Phoenix and in San Diego. However, there's a statute that layers on top of that changes things a little bit. And let me explain how that works. Under CRS 13-21-111, it says that contributory negligence shall not bar, I got to put on my reading glasses, not bar recovery in any action by any person or his legal representative to recover damages for negligence resulting in death or injury to a person or property. If such negligence was not as great as the negligence of the person against whom recovery is sought, but any damages allowed shall be diminished in proportion to the amount of negligence attributable to the person whose injury, damage, or death by which recovery is made. What does that mean? That essentially means that if you're found partially responsible for your slip and fall, your damage award is going to be reduced by that amount. So let's use a basic example. Let's say that you bring a claim and you recover $100,000 for slipping and falling in outside of a business in downtown Denver. You are found 25% at fault by the jury because they feel like you weren't necessarily doing everything you could have to avoid that situation, and therefore they assign you 25% at fault. So that leaves the business 75% at fault. So your damage award of $100,000 is reduced by that 25%. So you only recover $75,000. Now here's where it gets a little tricky. Under CRS 16-64-122, it goes on to say, if the plaintiff's share of fault is equal to or greater than the negligence of the person against whom recovery is sought, then, in such event, the court shall enter a judgment for the defendant. This simply means that if you're more than 50% at fault or found more than 50% at fault by a jury, you take nothing. You get nothing, you lose. So that's different than what we see in Phoenix and in California, which are comparative fault states, which essentially say that your amount of damage award will be reduced by the percentage of fault the jury places on you, but you don't take nothing if it's more than 50%, if fault is placed on you at more than 50%. So let's say in Phoenix or Flagstaff, Arizona, you have a slip and fall outside of business, and the jury says that you are 51% at fault. You would still recover the $49,000 in that same hypothetical where the total damage award was $100,000. That is not the case in Denver, Colorado. You get nothing. You lose. So it's a very distinct difference in that jurisdiction that you need to be aware of. Now, something else that I think is important to understand about the effects that snow has and the responsibility of a business owner or even a residential property owner are what are called snow removal ordinances. These are ordinances that are put in place by the cities, counties, and the state to ensure that sidewalks, areas in front of businesses, residential neighborhoods are made as or kept as safe as possible and made as the snow is removed as quickly as it can be, and those conditions are made safe and passable for those people that might be walking in those areas. Now, Denver had a snowstorm this past weekend that dropped 27 inches of snow in Denver. It's hard to imagine a situation where people can possibly remediate or get rid of all that snow overnight. But in Denver, for a business, you have 4 hours from the time the snowfall has stopped to begin to make the area in front of your storefront or on your premises safe and passable for pedestrians. For residential, as a resident for your home, you have 24 hours. You still have to use practicality. You still have to use common sense. It would be unreasonable, and that's the standard in the law, for someone to use or expect someone to have cleared all the snow 4 hours after the snowfall has ended when the snow drop was over 27 inches. That's the equivalent of, gosh darn near 3 feet of snow. It would be really hard to try to clear that much snow in a 4-hour window of time. So there's still reasonable standards, but the idea is to make conditions safe so that people aren't having to negotiate the snow, the ice, and falling and hurting themselves. So that's a little bit about Colorado law. I just wanted to update you on some of the statutes, some of the laws that apply there, and hopefully that can help protect you and make you more aware of your rights if you are involved in a slip and fall in Denver, Colorado, or anywhere else in Colorado for that matter. If you have any questions or you want to email me with any thoughts, please find my contact information on our website, negrettilaw.com. Until next week, thanks guys.